Hello and welcome. My name is Elena Volkova. I am here to present my virtual workshop on how to draft good client service agreements. A little bit of a technical introduction. If you are joining us through the web, please feel free to follow the slides, and if for some reason you can't hear me or if you can't get through, please email me with any questions you might have. There's also a chat and Q&A function on the webcast. You can use either of those, ask a question or chat. I will be monitoring both of those fields as we go along. So, just by way of introduction, I wanted to give you a little bit of a background on how this workshop came about. This happens to be a topic that is dear to my heart. It also happens to be a topic that is important to a lot of my clients. Unfortunately, I happen to work with people who had situations where they did not get paid or they had misunderstandings with their clients, and my job was to try and come up with some resolution so that that doesn't happen again. A very personal story. One of the reasons why why this workshop came about is that when I started my own practice, I wasn't always meticulous about sending out engagement letters to my prospective clients. So there was one time when I had a consultation with a prospective client. We outlined the scope of work for what I thought I would do for this particular business owner. And I went ahead and started working without getting any agreement in writing from this person or any prepayment. A couple of hours into the project, I sent her an email with my first draft, and the response is not a very happy response. The person was upset that I sent her a document that she didn't ask for. She thought that she was asking for a very small two-pager, sort of very simple document, and what I sent her was 7 pages long, and it was very comprehensive. So she clearly had something else in mind for the scope of work, and she wasn't willing to pay for my services at that time. I was insulted because I thought I was giving her a very sort of comprehensive document that would protect her and that it was worth all the trouble and the effort. Clearly, both sides did not understand each other, and I took a position that the client is always right, and I took it upon myself to basically say that going forward, I promised myself that I would at least make sure that I am clear at the outfront. At the outset of the relationship, that I will define scope and payment very clearly to avoid this very situation. As my practice evolved and I continue to work with service providers, what I notice is that when we are done preparing a form of a service agreement for somebody, they start to have a stronger sense of purpose, and they tend to have stronger relationship with their clients because they know exactly what the scope of services is. What is it that they're offering? What is their signature program? And the clients feel better for it. That gives client confidence that they're in good professional hands, and the relationship started to benefit from that. That's why I continue to have these workshops. I find that they benefit businesses, either beginners or people who have been in business for a while, because there's always something new that you can learn, a new practice that potentially you haven't thought of before. If you're watching on the webcast, I'm going to move on and progress to our next slide. And that one would be slide number 3, why and what. A well-drafted service agreement can help you make more money. As simple as that. When a client sees an agreement that was carefully prepared and easy to read and understand, they know that you mean business. You're also giving them an assurance that you know how the relationship will work. What sets a good agreement from a mediocre one is clarity and scope. And in this workshop, we will teach you how to outline all material business points to define proper scope of your agreement, what to expect from your attorney to achieve that clarity, and we will also give you a free resource on how you can start drafting your own service agreements. A note of caution to people listening. With agreements, one size does not fit all. The templates that we see on the internet created by potentially LegalZoom or NOLO, some of them are good and some of them are not good. And a good agreement really has to fit the specifics of your particular business. So an agreement that, for example, calls for provision of technology support services or web design is not the same kind of agreement that we draft for a photographer or a graphic designer. And an agreement that an attorney would draft would be entirely different for an event planning company. And those are all service providers. They just all have different specifics. The other important aspect is that licensed professionals like attorneys, architects, certified public accountants, doctors, they have to take into account their own ethical rules and regulations. And one particular profession that comes to mind is mental health. There's a lot of different licensed professions inside mental health. We have psychotherapists, people with a degree that's MD at the end of their name. We have analysts, people who have a PhD at the end, or MSW, or arts therapy, all sorts of different people that have licenses from, in our case, New York Department of Education. And these people are very highly regulated as to how much mental health they can provide to you. And another word of caution is that if you don't have the certification from from the Department of State as one of those professions, you have to be very careful that you actually do not provide those services. And that particularly applies to coaches who sometimes find themselves working, dealing with some heady mental health issues among their clients, and that's something that people should keep in mind, that they don't. In their service agreements, they don't hold themselves out that they can actually help people get better, that they basically are not providing mental health services. Another very tricky area where people have to be careful is financial services. I know a lot of financial planners, which is a title that is given by way of certification through a private training, but it's not a government-regulated title. Now, financial services is a catch-all for the sale of insurance products and also sale of investment products. So in order for you to sell stocks or bonds to people, or in order for you to sell insurance or receive compensation as an insurance broker, you actually have to have a license from the state to have to be able to provide those specific services. So that's something that just wanted to alert people to, and that make sure that their agreements address that, and in the scope specifically do not purport and do not hold themselves out as if they are doing something they're not allowed by law to do. So assuming you've gotten a client in the door, and assuming that you were retained to start acting, usually you would be expected to send an agreement to the person. Very rarely would you have a client, particularly if you're a small business provider, where they would send you their own form of a service agreement. But that's not unheard of, particularly for small business owners who work with larger businesses. Procurement departments in large corporations technically usually have their own form of a service agreement, and I call them a pro-client service agreement. If you have a chance, if you have any leverage, try not to use somebody else's form because it will not protect you. And who should really technically control the drafting? In my point of view, it's a service provider. If you're providing the services, it is expected that you will have your own form because that's just how businesses are generally run. You know your business best. You know how to set up the outlines of the relationship, and that's what will be expected of you, that you have a strong form of your own. It does depend in the relationship whether you're dealing with a large conglomerate. If you're very anxious to get a client and if using their form is really just the cost of doing business, then the best thing you can do is have your attorney review their form and make sure that you're protected to the best way possible. And some of the things to watch out for is the exorbitant insurance provisions. Sometimes they ask you for huge insurance protection so that you take out your own general liability insurance and have them covered as an additional covered. Those are the things that you should watch out for, and that's hopefully you're not going to find yourself in a position signing those provisions. When you're working with private individuals, those provisions usually are not applicable, and you should not volunteer them. Moving on. The top pressure points in an agreement. In the service agreement, the most heavily negotiated issues are usually about ownership of deliverables. In the service industry, what we provide clients basically comes out of our own head and then is memorialized in digital medium or on paper as what I call work product. For a graphic designer, it would be a logo, it would be a look and feel of a website. For a photographer, it's a beautiful portrait or a headshot. For an attorney, that would be a drafted agreement. So for the first two professions, it is expected, well, also for attorneys irrespective, it is expected that once you get paid from a client, the client will have ownership in whatever product you're creating for them. That's the commercial arrangement, which is different and distinct from when you are you're being commissioned to do an art project for somebody, and that's where you might retain some intellectual property rights in the final work. For commercial deliverables, what's customary and what's market is for the client to own intellectual property rights in the deliverables, as long, of course, as they pay you. And that's an interesting provision that I always put in contracts, is that the artist or the creator, the service provider, will retain ownership in the intellectual property, meaning in the photograph, the graphic design, the outlay of the website, in the jewelry, until the client has made the final payment. And that's super important because that gives you a lot of leverage in trying to make sure to get paid on time. Another pressure point is representation and warranties. Those are provisions, little provisions in the document that basically set out the informational foundation for the agreement. And as a service provider, I technically, I advise my clients that they really don't need to give much in terms of representation and warranties in writing to their clients, because the decision about hiring should usually have been made by that point, and the client has had a chance to verify whether you're qualified to provide certain types of services. So volunteering any extra information may not be helpful. And if it's not asked of you, then obviously I don't recommend that you put it in. And the other important note of caution here is that if you receive an agreement from a large corporation that has a long section on representations and warranties, as a service provider, you want to look at it very carefully, and you want to remove any of the representation and warranties that you're not comfortable giving, because any untruth or incorrectness in the representations and warranties may potentially invalidate the entire contract. Like you can't just corrected, it will give an opportunity to the other side to basically change their mind and say that doesn't work anymore for us. And by the way, this representation was not correct, and we want to cancel the contract. You don't want to be in that situation. So always be careful with this section that's called representation and warranties. And I don't recommend that you put it in your own document. And when somebody else gives you the form, try to take those out. Another topic that comes up often and something that I try to warn people about is indemnification. Again, that's not entirely appropriate when we have small actors like individuals and small businesses, because indemnification is quite expensive. It basically means that you will be paying for somebody else's litigation expenses if something goes wrong under the agreement, and particularly if a third party tries to sue one of the parties to the agreement. That's not warranted. It shouldn't be included, and it can only be included if both parties have insurance to back it up, liability insurance that would cover the cost of litigation. Now, when you're dealing with a large corporation as a service provider, indemnification is perfectly appropriate and is expected. And again, it's best if you have your own form of the indemnification language that you understand what's in it, and that it protects, it gives you just enough coverage in case there is a litigation. Another important provision, and we're on slide 4 for those, they're not, I think it's slide 7, sorry, slide 7. We are on slide 7. For those of you following me on the webcast, a limitation of liability. That's one of the provisions that people don't often put in their documents, and they definitely should, because it's allowed in New York, and it should be utilized as much as possible. What it basically accomplishes is if there is a dispute and the client either sues you or basically makes a complaint, you can always say that you will refund a portion of the money, but you will only refund or give back a portion of the money that is equal to, let's say, net profits under the agreement, or potentially $1,000. I mean, the amount could be whatever you want it to be, as long as it's reasonable enough to compensate the person for the nuisance, but also reasonable enough for you to not be significantly harmed, and something you can afford to pay, because you don't want to be compensating for people for any consequential damages or any of the arbitrary things that they may come up with. If you're an incorporated entity, another interesting provision that I always put in the agreements is to put something along the lines of an assignment. You want to have a provision that allows you to assign the contract to entities controlled by you, or you also basically allow for any successor owners to be parties to the agreement, and that's if you have a company. But you do not want to allow people, especially personal clients, to be able to assign the agreement to unrelated third parties. And this is what I mean. For example, somebody signed up to do a photography session with you, and they happen to be a nice client whom you like and very easy to deal with, and you quote them a fairly low price. They change their mind, and they turn around and they say, no, instead photograph my mother-in-law. And the mother-in-law happens to be a fairly demanding person who would not be happy with just one take, and she would require a couple of reshoots and maybe a lot of editing. Therefore, you will spend a lot more hours working with that person, and it really would be economically not advantageous to you to work for that same low price that you quoted originally. So that's something to keep in mind, and basically your agreement should not allow assignment to third unrelated parties. And these issues should be addressed as early as possible in the negotiation. And with small clients and private clients, it's not like you are going to have a long discussion about any of this. It really will be just for you to keep in mind, and keep, to the extent a conversation comes up, You have to have a position about those things, but if it's only to the extent that actually becomes important to a particular client. Now, with business clients, the way this will come up is that they will actually want to review a form of your agreement before they start the relationship or wire you any money. One of the questions that people ask me, and something that I've developed quite a significant expertise in, is how to structure a service agreement. The way I approach this topic is it has to be easy for a service provider to take the form of an agreement, include a couple of, just literally a name of a client, the date, and the price, and be able to send it out. Because client intake process sometimes can take up a lot of time, and if you're running your own operation and don't have a lot of administrative support, being able to send agreements out quickly together with invoices sometimes make a difference whether or not you're going to get the client. So I try and make sure that the structure works for that purpose, and the way we do it is we try and take all of the provisions that are going to be different from client to client into a separate section, which is usually attached at the back of the agreement. It describes all the services that the provider does, almost in the form of a Chinese menu. So whatever you can think of, either you package it as a package of startup incorporation kind of thing, or if you do it item by item and you list the prices separately, it's best to have the outline of services and the prices in the attachment to the agreement, and then all the generic provision would be included in the main body of the agreement. This way, it allows the client or the secretary or the administrative assistant of the client to fairly quickly prepare it and be sent out. And the other recommendation I often make to my clients is to include a provision for future engagements to allow for the client to use that same version of that same signed document to hire you for additional work and make it easy for them to hire you for additional work. And in more formal circumstances, even create separate statements of work and for the underlying agreement to work as an umbrella agreement for all future engagements. The drawback here, of course, is that if a relationship is not working out with a particular client, you don't want to be stuck on too many projects with that client. So you want to have some kind of safety procedures and back out mechanisms so that if you really would be better off working with another client and potentially winding down the projects, then you would have a very easy exit strategy. And that's something that we put in the termination provisions. We're now on slide 8 for those listening on the webcast. I wanted to also bring up another point. Usually there's a lot of back and forth that goes before the agreement is signed, and it's particularly a big topic and an area of concern for people who do proposals. They send out proposals, and then by the time the agreement is signed, the proposal has been modified significantly. So in hindsight, it creates quite a bit of a confusion in terms of what exactly was agreed to. And the best practice here is to put all the relevant terms in the final form of an agreement and also include a provision, a clause we call it, integration clause, that basically says that all prior emails or correspondence or communications related to the project are going to be disregarded for purposes of interpreting the agreement, that all relevant terms are included in just this one document. And that's to avoid future inconsistent interpretations and to avoid any disputes about scope. Again, that's to protect you. In the beginning of the webcast, I promised that I will give you a free resource, and it's actually located on freelancesunion.org website. They have a contract creator. The website is freelancersunion.org. /contract-creator. It is not going to draft the document for you, but it will give you a very helpful skeleton and structure. It's like an outline of your service agreement it's kind of like an essay where you will use the headings of that document to then fill in your specific information about price, description of services that you're providing. You will insert your name, and I actually find that to be a decent starting point for a lot of people. At least it does not have anything erroneous in it. So that's the free resource that's out there. One note of caution on business name. There's a lot of people out there who have incorporated as limited liability companies, or they have even corporations to their name, and they never use those. They continue to sign documents in their personal individual name. That's a mistake. Basically, forming a corporation, the whole idea is that you conduct business on behalf of that entity and not in your personal capacity. And you want the world to know in all writing that they are dealing with a business entity and not with you individually. And the reason why that is that if you happen to have significant assets personally and your business does not have significant assets, you want to make sure that people do not assume that you're good for the money if your business is not able to pay the debts as they come due. The description of services in a service agreement should come up fairly early on in the description. Like, you do not bury it in small print. And as I recommended earlier, it's best to have that section first and foremost basically saying that for the money that's being changed here, I will do the following things for you. And the easiest ways to do that is to basically say, I promise that I will deliver the services listed on Schedule A to this agreement. As simple as that. And then Schedule A is the list of all the things that you will do. When you describe your services, it's important to be as tangible and as specific as possible. You should not – I've worked with a couple of public relations companies where I really had trouble understanding where their job was ending. It felt like they were promising to make their clients famous overnight, and obviously that was not the intent of the public relations agreement. So the work that we did on that agreement is to be very tangible, which is 3 hours would be spent outlining the social media coverage, and then 2 hours would be spent actually drafting social media publications, and then 1 hour would be spent to actually publish the things that were drafted, basically the event copy that the public relations company was creating. So the way we worked around the ambiguity problem was to put the actual number of hours on the work that was being created, and also outline what the deliverables were, which is writing copy of a particular public relations campaign, have a strategy session with a client on what that campaign would be, and actually implementing it. But again, putting number of hours on it, because you could be on social media 24/7, and you sometimes don't need to do that. Yeah. So moving on, we're now on slide 11, scope of work. The scope of work is the most critical part of a contract and should be as precise as possible. Using clear language and defining terms will ensure you and your clients are on the same page before the work starts, and it will reduce the likelihood of any conflicts and misunderstandings down the road. In this section, please be sure to answer the following questions. What work will be done? What are the specific tasks to be completed? What are the deliverables? If applicable, include specifications such as format, quantity, size, color, material to be used, etc. Be as specific as possible. I cannot emphasize this enough. And be careful in calculating how much time will be spent on any particular project, because for a lot of service providers, time happens to be money. The timeline for your project is something that you only want to include if you are concerned that the clients will drag their feet. This particularly is applicable for web designers because those are fairly long and involved projects, and the fulfillment of a project depends largely on the client being able to provide content, photography, and intellectual property services for the website. So sometimes website designers are delayed by their client's inability to fulfill their end of the bargain, and the timeline becomes indefinite. You want to put some provisions in place to prevent that from happening. And from that point of view, you may want to consider including a timeline with approximate milestones, and build in some room for potentially your inability to deliver on time, but also protect yourself in case the client is taking too much time. In the scope of work section, it's also important to assign responsibilities. Again, in the example of a web designer, it is super important that the client is cooperative, because if they're not, the whole viability of a project is in danger, and potentially if the work is not completed, you're not going to get paid. So assigning responsibilities is super important. For some, and in fact, for many of my service providers, the location where the work will be done is super important. For example, I have event planning coordinators where they have 3 or 4 designated locations and with whom they have preferred arrangements and basically know those locations fairly well. They insist using those locations to make sure that they don't have to reinvent the wheel and get used to the new surroundings every time they have a new event. So it is often very important to specify where the work will be performed. Another important factor, for example, for photographers and videographers is to have their own designated locations for video and photo shoots, because this way they know whether they have the permit to be there, whether they are going to be uninterrupted, whether there is access to light, whether there is access to a certain location. And in order for you as a service provider to save time and money, you do want to specify that clients come to that particular location. How the work will be judged. I have yet to deal with a situation where the service provider has to prove to the other side that the work was done in a professional manner. That rarely comes up, and therefore we don't often volunteer provision that basically says that we will do our best in fulfilling your services. That just comes as a given, that we all do work to make sure that the clients are happy, and we do it in the way that we see fit. The second most important provision in an agreement is, of course, payment. Pricing of services is, a topic in and of itself, and we could be having yet another workshop on this. But the idea, of course, is you do want to be mindful of the value of your hour. You have to, as a service provider, you have to be mindful of how much time goes into producing a particular project for the client, and you also want to know the cost of any subcontracting work that goes into your price. Once you are able to determine the cost of doing the work, then you also need to know your market, competition, demand, and supply, and have some practice in trying to sell that product and see if it actually attracts people. I've seen a lot of clients who basically start their businesses and they know what the value of their services is, and they're willing to offer them at a slightly lower rate just to see if it generates any interest. Terms of payment. This provision is super important for small businesses because that could kill you or make you. For businesses that don't work on prepayment and end up fronting the fee and expenses for their clients, that is a massive cash flow problem. And you want to avoid it at all costs because not having enough cash to grow is just it really is a matter of life and death for a small business. In fact, it is. I insist that most of my clients put a significant prepayment provision in their document, and the reason why basically how they can justify it, even to the large corporations, to say that the reason why I'm able to offer the prices that I offer, which are reasonable compared to the competition, is because I work on prepayment and I save a significant amount of time and money chasing receipts and payables on my invoices, and I'm able to focus on my business more effectively. If you're dealing with an experienced business person, definitely this is something that will not come to them as a surprise. A lot of people also put a kill fee, meaning a cancellation fee, to make sure that they get compensated even if the project gets canceled. That is very important. Okay, if we now turn over to slide 14, let's talk about a little bit about expenses. Expenses are the things for which you are going to be out of pocket, meaning you will be buying things on behalf of your client. For in our case, oftentimes it's stamps, photocopy, FedEx, and depending on the amount of the expense, some of them get charged to the client and some of them do not. We usually have a cutoff rate. Anything below $30 we absorb, and anything above $30 we pass on to the client. We do not add any additional percentages. We do not mark up the expenses, and I don't recommend that you do either, because it just comes across awkward when you mark up somebody else's expenses, unless of course it presents a tremendous administrative hassle for you to track many invoices on behalf of the client and pay them and then turn around and invoice them back to the client. So in that case, I think markup is fair, but also try not to find yourself in that situation. That's just way too much work for a small business to handle. I think it's best practice for clients to, for all of us, to itemize expenses together with, price and description, because people do want to know that you're being frugal with their money. So there are two ways to go about expenses. You can disperse, as it really just means that you spend the money first and then get reimbursed from the client, or you basically ask the client to pay the vendor directly, and that's another viable provision, and it might save you a lot of headache and hassle. And the word of caution here is for the website designers. When you go ahead and purchase domain name and hosting service for your clients, try to put it's the right thing to do. The client's credit card should go, and the client should be the owner of the account as opposed to the web designer. Those things should not be held hostage, and you also do not want to maintain it on behalf of the client. I do encourage a lot of my clients to basically have a late payment penalty. It's fair to charge people interest if they don't pay you on time. In this day and age of electronic payments, there is really absolutely no reason for people not to pay on time, especially if they're using credit cards. So please feel free to put reasonable provisions in your documents to make sure that there's an incentive to pay on time. We are now on slide 16 of the presentation, and I wanted to talk briefly about conditions. Conditions is a very specific term that you want to have in your document if